Shri Vikas Singh sir is one of the leading senior advocates of the Supreme Court of India and the President of the Supreme Court Bar Association for a record third term. During his long and accomplished career as a legal luminary, Mr. Singh has also served as the Additional Solicitor General of Government of India. Mr. Singh is widely admired for his immense in-depth knowledge, perseverance, and complete focus on getting speedy and impactful judgment through his oratory and argumentative veracity. His re-election as the President of the Supreme Court Bar Association, a very prestigious position by itself, is a testimony of his professional reputation and popularity. Mr. Singh has always been engaged in supporting the Bar Association by contributing generously towards medical help and health care of needy lawyers. He has also been a visiting faculty member in the Indian Parliament for giving lectures on various issues including legislative drafting and legal education. He regularly appears pro bono in matters relating to important issues where the larger national or public interest is at stake. He is the only lawyer in India who has been associated with three prominent temple cases in India, that is the Ayodhya Ram Temple, Guru Ravidas Temple, and Bala Yogi Sri Sadanand Maharaj Ashram, emerging victorious in all three of them. Sir has also dealt with multiple milestones cases, including concerning those like administrative, constitutional, company, taxation, and criminal law, which has paved the way for historical judgments. Sir is also an avid tennis player and has also even played at a tournament at Wimbledon, which was hosted by the International Lawn Tennis Club of Great Britain. Sir is also very active in social causes, especially in providing help to the differently able people, and is also the chief patron of the Delhi Foundation of Deaf Women as well as in the treatment of the handicapped children. May I now, with utmost respect and admiration, invite Honorable Shri Vikas Singh Sir to kindly take over the podium and deliver the much-awaited lecture on the topic Importance of Election Commission in our Constitution.
First of all, thank you, Dr. K.V.S. Sarma, for inviting me here today. It's always a pleasure to be with young minds which are going to not only shape the legal profession in the years to come, but also shape the destiny of this country. So when Justice Ujjwal Bhuiya said that the university wanted me to come here, I immediately agreed. And unfortunately, because of my some personal commitments, I have to go back also today. So I can't spend much time in Guwahati, which much I would like to do. And also I'd like to apologize, I got a little late because I went to Kamakhya for darshan before coming here. Because I thought coming to Guwahati and not doing that darshan will actually make this trip incomplete. This subject I have chosen because I feel that the future of this country or the future of our democracy will largely depend on the legislators that we elect to govern our country. When Dr. Ambedkar finished the drafting of the Indian Constitution, he said that he has two regrets after completing the drafting of the Constitution. One regret was that he could not provide for the Constitution in the vernacular language. It was only in English that the Constitution would be made because of the diversity of the people comprising the Constituent Assembly. It was not possible to select any particular language or all the languages of the country for the purposes of making the Constitution. But the second is actually relevant today, and that is that he said that he did not provide for any qualification for legislators. He said that while people who will be administering the company, the officials who will be in charge of the administration are required to have very high qualification, the persons who will be deciding their fate, or rather who will be above them, or who will be in power, there is no qualification or any disqualification. A disqualification could have been, for instance, being charge sheeted in important criminal cases, serious criminal cases. A bureaucrat cannot think of joining any service if he is charge sheeted in a serious criminal case. That itself will be a disqualification for him to even qualify. But similar disqualification is not there for legislators. Now, the Constitution did provide this, and accordingly, a huge responsibility came on the Election Commission to try and keep the electoral process free and fair, so that the best of the people get elected to the assemblies and on to parliament. While the debate was on in the Constituent Assembly of providing for legislators, the qualification for legislators, it was discussed that when the British were ruling the country, there were times when the important leaders used to get arrested. And the debates show that whenever such important leaders who had a very mass following used to be get arrested, the society used to throw equally credible leaders to take their place. And that's how the freedom movement went on and on, with a lot of credible people fighting for the independence of our country. So the Constituent Assembly hoped that this behavior of a voter or of the people of this country would continue, and we will always get the best of legislators, notwithstanding there being no qualification or any disqualification. Clearly that hope has belied. Clearly 40% of our legislators now are having serious criminal cases against them. When the matter went to the Supreme Court of barring these cases, these persons from contesting, the Supreme Court said, unfortunately, we can't do anything about this. Because this is a matter of eligibility to contest, which only the Parliament can do. But how do you expect the Parliament to do something like this? When the Parliament itself is having almost 40% people with criminal background, you don't expect them to pass a law disqualifying themselves. It's like deciding your own fate. And days not far away when this number may cross 50%, the way the trend is in this country. Another feature of the Representation of People's Act, of course, which fortunately is challenged in the Supreme Court, and Supreme Court is looking at it very, very seriously, is of people getting convicted and then being eligible to contest for election after 6 years of doing that term in prison. And these could be convictions of serious offences also, of corruption or more serious offences. And still, after a 6-year gap, they can be again re-elected to the Parliament and to the Assembly. The Supreme Court says that if a bureaucrat or an ordinary person cannot think of joining the government after a conviction, why should the legislatures have this kind of privilege? And I'm quite hopeful that very soon we will have a judgment which will debar re-election of people with conviction. Now that brings us to the role of the Election Commission. Election Commission is constituted under Article 324. Now the article as it is framed gives complete sui generis powers to the Election Commission to decide manner and mode of election. When the first general election or the second general election were held, there was no concept of a model code of conduct. The model code of conduct came for the first time in the Kerala election of 1960. The election used to be conducted, parties were free to offer schemes, parties were free to, parties' power were also free to, continue doing with their welfare activities till the actual election day. But this concept was brought in 1960 that there should be a model code of conduct. This model code of conduct was given some kind of a, I would say, consensual backing sometime in the 90s when an agreement was arrived at between the Election Commission and the central government that certain activities like starting a new scheme in that area or announcing a new welfare measure for the people should not happen after the code of conduct kicks in, which is when the elections are notified. Now, when you can't announce a scheme, when you can't, announce anything, should money be transferred to the voters? And this is in many forms. One, money is of course transferring into the bank account of the voters officially. It is definitely worth debatable as to whether this should be part of the model code of conduct or not. Should the role of black money not be curbed in the electoral process? The only, if I may point out the first election commissioner who actually made the entire country know that there is an election commission, a vibrant election commission, which is ready to do everything and anything to keep the electoral process pure was Mr. T. N. Session. Mr. T. N. Session, when he took over the election commission sometime in the 90s, things had really, degenerated. There were booth capturing, money power, there were various malpractices which had started in the electoral process. People could get elected by using these malpractices, and it was going unchecked till then. So he came down very heavily, and if you all recall, of course most of you would not have been there obviously because you are all youngsters, but you should know that he was very unpleasant to the political parties because of what he did. And he used to do whatever he did on the plenary powers of the Election Commission. He says the Election Commission has to conduct a free and fair election. Today, under Article 327, there can be a parliamentary law to regulate how the Election Commission should also function during the election time. But unfortunately, there is no law under Article 327. So that sui generis power or that plenary power has remained plenary, and the Election Commission can do anything and everything. It can transfer officers. It can decide on what papers should publish. It can just think of whatever may be the reason which may mar the free and fair electoral process. The Election Commission is free to do that. And the Supreme Court also has empowered the Election Commission by confirming this power as far as the conduct of the election is concerned. One of the most celebrated judgments on the power of the Election Commission is Mohinder Singh Gill. I am sure all of you would have been taught that judgment in administrative law. There was an election in somewhere in Punjab where part of the constituency, there was some votes had been damaged, etc. And one of the contestants wanted to tell the Election Commission that this has not vitiated the election. You can only do a re-election of these parts, and the rest of the electoral process has been completely fair. And you should not cancel the election completely and order a re-election. Unfortunately, the Election Commission didn't give him a hearing, and ordered for a complete recall in that area. And when the matter went to Supreme Court for the first time ruled that natural justice is something which is ingrained in every administrative activity. Supreme Court said that even if you have to give a 2-hour notice, even if you have to give him an opportunity of telling him what his case is about, you can still take the same decision. But you have to adhere to the principles of natural justice. And of course, in that case, no relief would be given to that gentleman, but the law was laid down for the country. And of course, now we have seen how in administrative action now natural justice is read as an integral part of decision making, and courts are always ready to look at any decision which is taken which violates the principles of natural justice. Now the Election Commission, when it has been given this authority to take any call with regard to an election, whether it be annulling the election or ordering a recall or transferring an officer or doing everything under the sun to maintain this election, has the Election Commission failed in its duty in curbing black money in the electoral process. A very disturbing thing has started, and which is what I feel I should talk to these two young minds like you all, and you all should also think about this. And I'm sure with the collective wisdom of this, the new generation, which is you, I'm sure we'll think of some solution for this. This time when the elections were being held in Bihar, somebody came to me asking for a Congress seat. And he says, sir, आप जानते हैं इसको आप बोल देंगे मेरा सीट हो जाएगा. हमने कहा भाई तुम्हारा कोई चांस है जीतने का? बोले नहीं हमने बहुत काम किया है सर, हम जीत जाएंगे. Then he volunteered that I have also a lot of money I can give to the political party also, I can give in the election also. He was wanting to contest against a very powerful politician of Bihar, and I was sure that there was no way he's going to win. But where is black money consumed 100% in today's society? If you want a lot of black money, even if you want to buy property, 50% though you'll have to pay in check, or maybe to 30% if you're lucky in the scheme. But that much white money you will require. The electoral process is one such process today, unfortunately, where 100% black money can be used. It can be used for getting a ticket for yourself by paying somebody within the political party, and it can be used for contesting the election. Now, what happens when a person who spends crores and crores of rupees and loses the election? What does he still achieve? He achieves recognition, which recognition he could have never got in his entire life. He is considered a neta for all times to come, even after losing the election. Recently, when Mr. Harish Mahajan, that exporter, very big exporter of Delhi, his house was burgled. He's worth something like 20-30,000 crores. When his house was burgled, the press carried Sonam Ahuja's father burgled. Why? Because nobody knows Harish. He may have made a lot of money, but he's not known. He's known as father-in-law of Sonam Ahuja. So when you enter into politics and use your black money, you become suddenly known. You become a neta. Your face is recognized by people. This is the curve which the Election Commission needs to do. And this was quite effectively done during the TN session time when money, liquor, all kinds of inducements were being given during the election time. And he could, come with a very heavy hand. Since the powers are so generous, the entire administration is at your command. You can command police officers to put pickets. You can ask these paramilitary forces to check it. You can ask checking of every vehicle to be done. You can ask every political party office to be, inspected on a daily basis. Ultimately, money will change hands somewhere or the other. There has to be a method of distributing so much of money amongst the people, and that method definitely can be, if you really want to, checked. You have the income tax at your command, you have the excise department at your command. Every authority in the government of India or the government of a state is subservient to the election commission under Article 324 when the election is notified, or even before the election is notified, as far as preparing the voter list is concerned. We all need to introspect whether the election commission has failed this country as far as curbing black money is concerned. A very interesting case arose in the Supreme Court with regard to electoral bond. You could pay money to a political party and your name had to be not disclosed, and that money was considered to be not or reduced from your income for the purposes of computing your taxes. Supreme Court set aside the electoral bond, saying that it is arbitrary. But why should not the money which the political parties had collected on the basis of a illegal bond should be returned to the person who had given that money? Even the bond which was started initially, when there was no anonymity there in paying money for the electoral bond, there used to be a tax exemption still available. You could pay a particular sum to a particular political party and claim tax exemption, or that much money used to be reduced from your income. Why should that happen? If I am paying to a businessman paying to a political party, obviously I am doing it for some benefit that I think I will get over a period of time. Ultimately, we have to think of ways to fund the election by the exchequer. Bond is a good way out, but not the way it was implemented. A investment in the bond should be always to a common pool, without knowing who will be using this money. In that case, it can be made a deduction from your income tax. And that money should be then distributed on some intelligible basis, which may be either the votes percentage that a political party has, and that funding should be happen through that bond. Because unless we prepare or unless we come to a system where the entire funding of an election is done by the state, we will never be able to ensure the black money going out from the electoral process. Now, these are very, I would say, important questions as youngsters you all must think about. That where are we heading to? Is this the freedom that we fought for when we got independence in 1947? Are these the credible people who we had thought would be governing the country in the years to come, who would be getting elected into the parliaments and the assemblies? Are these the people whom we had envisioned that they will be governing the country? If they are not, then there is something very seriously wrong. And definitely, there is something which can be done by the parliament. The parliament can debar candidates with criminal background. Parliament can bring in a law, there is no difficulty. On the contrary, the law as it stands today, of course, it was made in 1951, so we really can't, because that atmosphere was different at that point of time. The caliber of people in politics was very different. There was a lot of nationalist feeling in the country. So the law that was made in 1951 provided for even convicted people getting back into parliament after 6 years. But do we need to have that kind of law even today? If the parliament is not in a position to make a law or not willing to make a law, should the courts do something about it? In my view, and I've argued this in Supreme Court in several matters. In fact, there are some public interest matters where I'm also arguing for some petitioners who claim that this law should be brought about. If the Supreme Court can bring in a law for by a judgment on gender justice or on many other on environmental matters, I think it is high time that the Supreme Court should rethink of whether to leave this issue to the Parliament or decide it itself. Because otherwise, we are moving towards a very dangerous trend. And why people like you, youngsters like you, are important? Because the recent happenings in Nepal and Bangladesh are a clear testimony that it is the youngsters of this country who can bring in change. It's the youngsters of the country who have to think about nation building and to move towards that. The youngsters during independence were fully engaged in nation building. We know of kind of sacrifices that our freedom fighters have done. People have lost their lives also. People have been hanged, all for the nation. If the nation at that point of time had that kind of metal of people to die for the country, for a political cause, for independence, I don't see why the youngsters of today should not also think about this and raise these topics for discussion and make it a national debate of how to ensure that the corrupt are kept out of the electoral fray, whether it be by the Election Commission or by a law made by Parliament, but there we have to find a solution. And if that solution is not found soon, we are moving towards something which definitely is not desirable in the interest of the country. Article 324 has been used by the Election Commission to manage the elections in the entire country. Article 324 has been interpreted to give the Election Commission plenary pass to do whatever is good for the process. The SIR activity which is going on by the Election Commission. Election Commission has the full authority to revise the voter list. When I say revise the voter list, means it has the authority to exclude names of people who have died and add names of people who have become voters by virtue of gaining the age of adult franchise. In my view, this SIR activity is not meant to disenfranchise anybody. It can't be. It's the job of the Home Ministry. A person who has been considered to be part of India or in the voter list in the earlier election cannot, in my view, be disenfranchised by an SIR activity. Matter is sub judice. I don't know which way it will go. But I personally feel that this is also an overstepping in the jurisdiction, because ultimately, rather than doing good things for ensuring a clean politics, you are getting into an exercise which really is the job of the Home Ministry, that is of deciding the nationality of an individual. Just imagine a person in the village, a person living in a small town. What does he have to prove his citizenship? What do you have to prove your citizenship if you don't have a passport? It's only your residence that you are staying in that area. You may have, you can show your father was also staying in that area. You may have an Aadhaar card or you may have a ration card. But if somebody is having all these cards which you are also having, can there still be any power with the Election Commission to say that you are not a citizen of this country? In fact, I look at it a little differently also. When the election is to be held and this person whom you are wanting to disenfranchise is residing there, is he not a stakeholder to ensure what is best for that area? If he is getting the benefits of the schemes of the government, for whatever, when the government decides a scheme by virtue of his Aadhaar card, is he not a stakeholder there? Either you evict him from there, you send him out of the country, find out that he is not a part of this country, but if he is going to be there and he is going to continue to live there, should he not vote? Is he not the person who should be having the right to decide who should be elected? Because he is very much residing there. He is the beneficiary of the schemes which the government is framing. He is also interested in good governance in that area. So I think the Election Commission, instead of getting into the real job which it should be doing, is getting into exercises which are clearly avoidable, so to say. What has happened in West Bengal yesterday, what the Supreme Court has done to ask the judicial officers to look at the electoral process, is something which is not, according to me, a healthy thing in a federal structure that we have. A trust deficit between the state government and the Election Commission. Mamata Banerjee the other day, she came to Supreme Court and she says, I've been writing letters to the Election Commission, they don't even respond. Just imagine the ruling of Mohinder Singh Gill. Does a political party not have a right to at least voice whatever it may have to say and be heard even in a summary manner of what he or she is wanting to say? If that also Election Commission is not ready to do, I think somewhere Election Commission is failing in its duty as far as the conduct of the elections is concerned. The Election Commission has a huge staff with itself to do this online, this exercise of revising the voter list. And we have all seen, I have also seen my voter list also has been changed. I have changed houses, I have changed places. They do this exercise and they are obliged to do so, and that is within their remit. But to say that I am not a citizen or a citizen of this country, according to me, is not their remit. So I personally feel that a stage has come where people should ask this question of how to ensure, how to cleanse the political system in this country, how to ensure that people of merit or of character are elected, and our rights should be determined by such people rather than people who themselves are lawbreakers and can't be trusted upon for the purposes of our governance. So I think my time was half an hour and I'm also in a bit of a rush. I have to take a flight back today. So I think there is a question answer session after this. Yes. So I'm ready if anybody wants to ask any question. You have to sit there? You have mic?
Mic. Yes. Mic. Here is it. We have mic.
Thank you so much, sir, for that thought-provoking speech and highlighting the stark reality of the electoral process. Now, the floor is open for a Q&A session.
Good afternoon, sir. My name is Shivan and I am having a question. Sir, the courts take a lenient approach in the most heinous of the offences, believing that the accused can be redeemed. But when a politician gets convicted and he finishes his sentence, why shouldn't he be given the chance to contest the election again? So this can also be redeemed. People with a serious criminal charge gets freed after conviction and returned to the society. There is a redemptive theory that shifts the focus from the past act of the criminal to the future criminal. Says that hate the sin, not the sinner. So, Section 8 of the Representation of People's Act imposes a ban for 6 years after finishing the sentence on contesting elections based on the serious criminal charges. There is a challenge in the Supreme Court that there should be a lifetime ban. So, why there is a differential approach for the politicians and for the normal criminals?
So when you're talking of politicians here, the comparison is not with normal people. A normal person will always suffer with the stigma of having been convicted. The comparison is with a government servant, with a clerk, with a peon. Does he not also, can he not also redeem himself? Can he not also be, why should not the clerk also get his job back? Why should not a bureaucrat also get his job back? Is the question which is really posed in the Supreme Court. That if there is an IAS officer or an income tax officer who's convicted, is there any possibility to give him the job back after 6 years of serving the sentence? If there is none, then there can't be any higher treatment or better treatment to politicians.
Thank you, sir.
Good afternoon, sir. Sir, I'm Saket from LLM. So my question is that in 2013, the CIC, through its order or judgment, declared 6 national political parties under the ambit of RTI as public authorities. But out of those 6 political parties, none have challenged them, but they have also not complied with that particular order. So, do you think that the Election Commission of India under Article 324 has, or through its plenary power, should have a constitutional obligation to declare or to ask that political parties to come under the ambit of RTI by declaring them as public authorities, or if one is going to declare the political parties as public authorities, it will undermine its political autonomy. What they say that if we come under the ambit of RTI by declaring ourselves as public authorities, it will undermine our political autonomy.
So once there is a declaration already made that you are a public authority, your only choice is to either challenge it in the higher court or Supreme Court and say that this declaration is not correct. But once that declaration has happened, there is definitely the political party should be part of the. So this argument is done by even a lot of these autonomous organizations today, where they say that it is affecting our autonomy by this RTI that has been enforced. Now RTI, what is RTI? RTI is basically a disinfectant. Sunlight is the best disinfectant. And according to me, the whole purpose of RTI is to make everybody know what is happening in an organization which can be said to be a public authority. Now, if political party have been declared to be such, definitely the election commission should take some action against them, either de-recognize them or do something of that sort. It can't just sit quiet on that once that decision is taken. Either if it doesn't agree, then it should challenge it in the higher court.
Thank you, sir.
So my question is in the context of Article 324 and the current SIR case. So as we have seen, there are a lot of questions about the extent to which the word superintendence and control and direction of elections should be interpreted. So my question is, do you think that the Supreme Court at the very least needs to give some sort of guidelines on what superintendence and direction of election means in the context of, let's say, questions like determining citizenship, which have become very relevant in recent times?
If you read the Citizenship Act, declaring somebody not a citizen is clearly with the Home Ministry, and there are parameters to do that. It's not some exercise which can be done. So when you declare somebody who is so far enjoying the citizenship as a non-citizen, then there is that process has to be followed under that act. If that process is not being followed, and simply by disenfranchising them, you still don't make them non-citizens of the country without that procedure being followed. And what are you ultimately doing? You are ultimately not permitting a stakeholder in that area from participating in the election, and also not able to throw him out from that area. Either you throw him out, send him to, if there is from some foreign country, send him to that foreign country. But it is not, if he can't be sent, then what are you achieving by doing something which is clearly not your job?
Good afternoon, sir. I'm Gopal Krishna from LLM. So my question to you is, so you mentioned about youth in Nepal and Bangladesh, right? So my question to you is, one of our senior leader, he said that asking a question or raising contentions is anti-national. So why youth like us should ask questions and go to jail or have multiple FIRs against us and destroy our careers? Thank you.
Now that's a difficult question to answer because that's getting into. So you have to keep your debate within limits. So you have to only like what I said. I mean, this is what you all can say. But if I'm not going to jail, then you're also not going to jail. I can assure you that.
Good afternoon, sir. I am from LLM department. I want to ask you a question on should election commission should be independent body or it should be dependent on some government body?
Now that's a very, very interesting question. So recently the Supreme Court had ruled that the election commission should be appointed by a collegium of which the leader of opposition, the Prime Minister and the Chief Justice of India should comprise. Idea was that the Prime Minister should not have a majority in the appointment process or have an ultimate say in the appointment process. Now that judgment was delivered after looking at the important role of the election commission in our democracy and saying that it can't be that election commission should be appointed by the executive. Now that law was challenged in Supreme Court, and after this judgment they came up with a law which you all know is where the Prime Minister and a Cabinet Minister and the leader of opposition decide who will be the election commissioner. Obviously, since they are in the majority, really speaking, the leader of opposition has no say in the appointment process. So this was also challenged in Supreme Court, this law, saying that this is clearly contrary to the earlier judgment of the Supreme Court. And once a judgment has been delivered on a particular subject, you can change the basis of the judgment, but you can't take away the reasoning of that judgment. And the reasoning clearly was that the commission should not be appointed by executive influence. But unfortunately, Supreme Court did not stay, and unfortunately, the law still holds the field. And with the result that the election commission is being appointed by the government itself, which is according to me not correct. And as far as the other dependence is concerned, the election commission is not dependent on the government for its funds or anything. Whatever the election commission wants, it is getting, and there is no. That part of the independence of the election commission has always been maintained, and if ever the government were to try to curb that, I'm sure the courts will definitely intervene.
So the 138th Amendment Bill, which introduces what some call the disqualification by suspicion, wherein a minister or whether a cabinet minister, prime minister, chief minister is automatically removed after 30 days of detention without a trial or conviction. So when we see it from a constitutional standpoint, so does this not invert the presumption of innocence of that particular individual, whether he is a chief minister or the council of minister? So also there's, if such a leader is subsequently acquitted and he can though there is a provision that someone, if after being acquitted in that particular charge, he can be reappointed, but that reappointment does truly undo the damage to the electorate's mandates, or we can say that, and the principle of separation of power in this case regarding this recent 138th Amendment Bill.
So I don't agree with this law, because if you have not disqualified your MPs and your legislators because of criminal charges or even having suffered sentences in jail, I don't think this law also will stand the test of judicial scrutiny, because there was a case made, if you all will recall, when I think in the UPA 1, when some people with criminal background were taken inside the ministry. A case went to Supreme Court, and Supreme Court said that even if you are having criminal background, even if you have suffered jail sentences, the decision to appoint is with the Prime Minister or the Chief Minister within the members of the Assembly or the Parliament, and the court cannot do anything about it. So if having already ruled in that favor, I don't think this law will stand the test of judicial scrutiny. If you have not disqualified people from entering the House, then you also cannot disqualify people from holding on to these. And in fact, you'll be surprised to know a president of the United States of America can work technically from jail. There is no bar for him to working from jail. So it's not something which is very unique to our Indian system. And if there is a person who has been elected and if he is the leader of the party, he can continue to serve even if he goes to jail.
Thank you, sir.
So I would like to now take leave because I have to actually take a flight back. So thank you for very engaging with all of you, and I'm sure it will make you all think about what is happening into the system today.
So thank you so much. So before winding up, I would like to request Nishika Chauhan from second year to deliver the formal vote of thanks.
Good afternoon to everyone present. On behalf of National Law University and Judicial Academy Assam, I am honored to propose the vote of thanks for today's special lecture. It is truly a privilege for us to have Mr. Vikas Singh, Sir, President of the Supreme Court Bar Association and former Additional Solicitor General of India with us. Sir, we are deeply grateful to you for your illuminating lecture on the importance of Election Commission in our Constitution. Your insightful analysis highlighted how the Election Commission stands as a vital pillar of our democratic framework and should be safeguarding the integrity, fairness, and credibility of elections. Your remarkable legal journey, your contributions to landmark cases, and your continued dedication to public causes serve as a profound inspiration for all of us members of the legal fraternity. We are truly grateful for the wisdom and perspective you have shared with us today. I would further like to express my sincere gratitude to our Honorable Vice Chancellor Professor Dr. K.V. Sharma Sir and the University Administration for consistently ensuring that students receive opportunities to engage with eminent legal luminaries such as our distinguished guests today. I also extend my heartfelt thanks to our respected faculty members and for their presence and guidance, and to the administrative and support staff for ensuring the smooth conduct of this lecture. Lastly, I thank my fellow students and research scholars for their attentive participation. With these words, I once again express our sincere gratitude to our distinguished speaker and to everyone who contributed in making today's lecture a memorable and enriching experience. Thank you, and we conclude today's